Let's talk about some of the really big ones, particularly of interest to the business community. And let's start perhaps with that union case. Take us through it.
Yeah, this is a case involving whether government sector workers can be required to pay for part of the cost of collective representation. Now, back in 1977, the Supreme Court said, yes, they can, as long as those fees don't go to political or ideological activities, and the court is thinking about overturning that decision, which would mean that workers have a free speech right to say, no, I don't want to pay those fees.
Yeah, and specifically this is public unions, but after all, that's really where the power is shifted in the country. So the unions say this is critical to their future.
Yeah, we don't have a firm estimate as to how much money might be at stake here. People don't really want to, particularly the unions, don't want to talk about how many people might opt out of paying those fees. But it could affect potentially 5 million workers in about 22 states where right now workers do have that right to opt out.
But could it also affect on the other side, the people negotiating with the unions? Because if you have a lot of people who are not actually paying their dues, not participating in the union, that maybe the union has less clout to extract, for example, higher wages, better benefits.
Yeah, and this whole doctrine, this idea that you could require these fees, was originally crafted in the interest of the government. The idea being that it's easier for the government just to have one bargaining unit to deal with, rather than have all these workers say, no, I don't want the deal the union is cutting. I want to, form a separate union, or I want to disassociate myself from the union's positions on things.
And the claim against requiring this is a First Amendment claim, as I understand it. It's a right of association. There's another First Amendment case up there involving wedding cakes. Explain that to us.
Yeah, this is one that's really caught the public's imagination. It started with a Colorado baker who said, I don't want to make cakes for same-sex weddings. A same-sex couple who was getting married in Massachusetts came in there, wanted a cake to celebrate their wedding. He said, no, I don't make cakes because I have a religious objection, and I feel like it would be, I would be expressing myself by making a cake for your wedding in a way that I'm opposed to. Colorado has a civil rights law that says you cannot discriminate on the basis of sexual orientation, and the state civil rights officials say that this baker has violated that law by refusing to make cakes for same-sex weddings.
So, Greg, I'm fascinated by this case because I thought we'd sort of litigated this in a different guise back under civil rights. I mean, if you go all the way back to the Housing Act and things like that, people were making all sorts of claims that I should have a constitutional right to the government not tell me who I have to rent a room to, for example. Why is this still alive, or is it a different set of arguments?
No, it's a very similar set of arguments. And if you talk to folks on the gay rights side, they'll say it is almost identical. There's a Supreme Court case from decades ago in the civil rights era called Piggy Park that involved the owner of a barbecue restaurant who didn't want to serve black people. And among the arguments he made was that he has a religious objection to doing that. And so the question, part of the question here is the court going to treat discrimination on the basis of same-sex of sexual orientation differently than discrimination on the basis of race?